are on the record in the matter of the Wyandotte versus Danielle Butler, 24720.
Good morning, Your Honor. Attorney Corey Westmoreland appearing on behalf of Ms. Butler. Ms. Butler, would you please state your full name for the record?
Okay, that did not come through. Did that come through?
No.
You have to be much.
Danielle.
Okay, perfect. Thank you. All right. Good morning. Today is the date scheduled for a show cause in this matter. Your client had previously been on probation, and then I believe she was discharged early based on the requirements being met. But apparently there was not a diligent effort for your client to complete to make payments, so she probably should not have been discharged from probation. But in any event, counsel?
Yes, Your Honor. After speaking with Ms. Butler in regards to the show cause, we are prepared to waive any sort of contested hearing and each that they guilty to.
All right, please raise your right hand, ma'am. You solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yeah.
Okay, ma'am, I've already said once, you're not loud enough. You need to be much louder so we can get, you can't speak when I'm speaking. You need to be much louder so that we can get your recording on the recording. Got it? I'm either gonna have to call this matter again when you figure out how to be louder, or I need you to be louder right now. Do you understand?
Yeah,
Are you picking that up, Ellie?
that was good. Yes.
Very good, thank you. Now, so is that yes? You solemnly swear from testimony about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes.
Did that come through?
Yeah.
Okay. And ma'am, you heard the allegations that you did not pay, make payments and pay your fines and costs in full, correct?
Yeah.
As to, and then you did not appear in court when there was a request as well. And so as to the show cause hearing, how do you plead? Guilty or not guilty?
Guilty.
Did that come through?
Yes.
And you do understand you have the right to have a contested hearing in this matter. And by entering into a plea, you will not have that contested hearing. Do you understand that?
No, can you go over that? I don't understand.
Okay, did you speak about it with your attorney?
Correct.
You did. Okay. So I will clarify then for you that there has been a motion filed that alleges that you are in contempt of court because you did not pay your fines and costs. And you have the right to have a contested hearing, which means that there would be witnesses that would have to come into court to show what you did or did not pay as to whether or not that is something that you are guilty of or not guilty of. By entering into a plea, you will not have that contested hearing. That's what that means. Do you understand that?
Yeah.
All right. And you understand the possible penalty, whether in this court, any other court or administrative agency.
Yeah.
Knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
Mm.
Are you picking that up, Ellie?
Yeah.
Okay. All right, counsel, if you can please voir dire your client.
Ms. Butler, were you on probation through the Wyandotte District Court?
Yes.
As a term and condition of your probation, were you to pay costs and fines?
Yes.
Did you fail to do so?
Yes.
Is that coming through, Ellie?
Yeah.
Okay.
And you understand that's a violation of the terms and conditions of your probation, correct?
Yes.
Satisfied.
I didn't hear that last part.
Correct.
All right, the court is satisfied the plea is knowing, voluntary, and factually accurate. And counsel?
Yes, Your Honor. At this time, Ms. Butler does acknowledge that she does owe the money to the court. She would be requesting to set up a payment plan. She currently is not working, but she's going to find a way to make sure she pays costs and fines off people.
Okay, and so ma'am, how much did you pay any? Did you make any payments while you were on probation?
I made all of my payments on probation.
Okay, Ally, what does it show as her balance, please?
The balance is $1,298.40.
How much did you pay per month, ma'am, while you were on probation?
In between 20 to 50 hours.
Okay. And so you understood that that was not going to make, that that was not going to pay your balance in full, correct?
Correct.
All right. So you have been discharged from probation since April 30th of 2025. Did you set up a payment plan upon your discharge? I can't hear you.
No,
Why not?
I didn't think that I set up a payment plan. I was just paid it on
When were you intending to do that?
when I got the money.
And when would we know when you're getting the money? There has to be communication with the court. Why are you not working?
Because I haven't got a call back from the jobs
When's the last time you were employed?
a month ago.
And why are you no longer employed?
It wasn't no hours. I wasn't getting.
So you quit? You,
I really wasn't working like that. I wasn't getting any hours. I had a job, wasn't getting
okay, where were you working?
intercom.
I can't hear you.
Period.
Okay, and so you weren't getting any hours. You're getting 0 hours?
Basically, yes.
Well, it's either 0 or there's more than 0.
I was getting 6 hours a week.
Okay. And so while you were only working 6 hours a week, were you applying at other places for work?
Correct.
Okay, well, ma'am, what is your plan for paying this almost $1,300 balance off?
This case assessment.
I can't hear you.
Getting a job and making a payment plan.
Okay, and so, where have you been applying? How many places have you applied since you've been unemployed?
Probably like 400. I applied to a lot of jobs.
Okay, and so how are you supporting yourself right now?
I don't have any bills open.
All right, and so council, what's the proposal?
Your Honor, at this time, she indicated to me that she could make a $25 a month payment until she does find employment. At that time, she would assess her situation, and make bigger payments as she can do so.
All right, and are you intending on making that payment, beginning the payments today?
No.
No? When are you planning on beginning the payments?
Whenever I find a job.
Okay, ma'am, do you have somebody you can borrow the money from then? $25 a month?
I can ask.
Well, you don't have any bills right now, so I'm presuming somebody's supporting you.
I can make a payment by December 1st.
All right. Okay, ma'am, make sure that you are continuing with that payment. If you need to, you can get the online payment information from the window, so you don't have to make the trip in to make that payment. Okay? All right,
Thank you, Judge.
have a good day. Thank you. We're on the record, the matter of the state of Michigan versus Michelle Beaver, 251296.
Your Honor, good morning. Richard T. Serrano, P33828, appearing on behalf with my client. She's presently in custody in the Wayne County Jail. This is the date and time set for her sentence. And please state your name for the record.
You need to unmute, ma'am.
Michelle Ray Beaver.
Okay, today is the date scheduled for the sentencing in this matter on your client's plea to operating while visibly impaired. I gotta tell you, counsel, I'm not really sure how your client was charged with impaired when she had a .286. But in any event, that's what she pled to. Your client is currently in the Wayne County Jail because she had a bond violation hearing where it's alleged she consumed alcohol, a lot of alcohol. And so the court revoked her bond and she's been in custody since October 20th in this matter. And counsel, did you have an opportunity to review the report and recommendation with your client?
I guess we have, Your Honor. I believe she was in custody and then released on a tether and then back in custody. Is that what the court shows?
So she was arrested September 2nd. She was arraigned September 4th. And she was on an alcohol tether through the Wayne County Jail. She appeared in person at her next court date. So I would presume she was in custody for a couple of days awaiting her tether.
All right, we just want to make sure if jail is levied that we get the correct credit for time served.
Okay,
But Your Honor, my client has a job waiting for her if and when she's released. She's going to be working at a nursery, helping out there. And she's currently going through a divorce now. It's a little difficult being incarcerated. Your Honor, she understands she has problems with alcohol. She told me that she would like to seek some treatment and not in anything presently. We hope the court would consider that. The recommendations are okay, I guess, but of course, we would try to ask the court to continue her tether and release her. If not, Your Honor, she's ready for the court sentencing. She'll abide by that. Obviously, she'll need time to pay fines and costs if and when she gets out.
okay. Well, counsel, your client is not currently on a tether. It's been revoked because she violated the tether by consuming alcohol. And Ms. Beaver, I believe, acknowledged that she has a significant issue with alcohol. Would that be accurate, ma'am?
Yes.
Okay, ma'am, you are 0.286. You're nearly 4 times the limit by which somebody is deemed to be legally drunk. And there was also a firearm in the vehicle. And apparently there are some other issues that occurred because there's a number of police reports that occurred that day. And I'm not even really sure what happened, but like entering without permission or whatnot. But in any event, your client was charged with operating while visibly impaired and open alcohol. And ma'am, do you want inpatient treatment? Is that what you're hoping to get?
Yes, ma'am.
Great, we're going to help you with that. The court is going to order after hearing from counsel, from Ms. Beaver slightly, reviewing the report, the recommendation. The court does not find that there's reasonable grounds to Department MCL 769.5. The court's going to order 90 days jail. The court's going to give credit for all right, so your client's been in custody. She was in custody for 26 days because the appears as though she was taken into custody on October 11th. No. October 12th. So that's 25 days. And just so, counsel, I'm not sure if you recall, but your client, while on bond, reached a level of 0.397. Somehow she was not hospitalized. So, and the court, so that's 25 days, plus the court will give 5 days credit for time your client was awaiting her alcohol tether. The court's going to order your client can be tethered to treatment, inpatient treatment upon her request. So ma'am, that means if you want to be tethered to treatment, you need to be the one to request that through the Wayne County Jail. I will make a note that you may be tethered to treatment upon your request.
Thank you, Your Honor. Your Honor, does this also include the alleged bond violation, or is that going to be some type of a separate hearing?
That's already been handled.
Oh,
October 20th, that was handled.
I see. Okay, thank you.
And then as to the fines and costs, the court's going to order a $300 fine, $100 screening assessment fee, cost prosecution, $300, crime victim assessment fee of $75, justice system assessment fee of $50, $825. Ma'am, for right now, I'm going to set up a payment plan for you of $50 per month, beginning February 1st.
Thank you.
All right, that gives you plenty of time to complete your 60 days and start the job you say you have. In the event, ma'am, you cannot do the $50 per month beginning February 1st, please email into the court so that we can work with you. All right?
Can I ask a question? Email
Sure
to the
may.
court. Email to the court. How do I do that?
Well, if you look on our website, you will see the court email. There's a court email, a general court email that's monitored. Okay? Or you can come in person to request a different amount or different date for the payment. Okay?
Okay,
Best of luck to you, ma'am.
thanks.
Let's go on the record in the matter of the City of Wyandotte versus Dylan McAuliffe, 211099, 251136, and 211485. And that's it. A.
Attorney Corey Westmore, appearing on behalf of Mr. McAuliffe. Mr. McAuliffe, would you please stand for full name?
Dylan McAuliffe.
Okay, so we, the two older matters are both driving with license suspended matters that you failed to appear on. So we have to arraign on those matters as well, counsel. And then we have the new charge of possession of controlled substance. So as to the arraignment on all these matters, counsel,
Yes, Your Honor, at this time we are prepared to waive the formal reading. My client stands mute.
the court will waive the formal reading on all these matters. Enter plea of not guilty on all of these matters. And counsel, as to the plea agreement
Yes, Your Honor.
or the pre-trial, I'm sorry.
At this time, the 211099 matters being dismissed. The 2114 to allowing an unlicensed driver to drive. And the 251136, my client's prepared to plead guilty as charged with consideration for a delayed sentence.
Okay, sir, your attorney worked out a very good deal for you, given that you have two of the same charges within a month of each other in 2021, and you failed to appear for 4 years. Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right. And you heard the pleas that were placed on the record, correct?
Yes.
As to case number 211099, the amended charge of allowing a licensed driver to drive, how do you plead?
Not guilty. Guilty.
Okay, I don't need you to guess, sir. I need you to tell me are you pleading guilty or not guilty?
Guilty.
And you've gone over your advice of rights with your attorney, correct?
Yes.
You understand all of those rights.
Yes.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes.
You've gone over your advice of rights. I'm sorry. Also, as to case number 251136, how do you plead?
Guilty.
That's the possession of controlled substance. And you also understand your rights as to that matter as well, correct?
Yes.
And you understand the possible penalty as it relates to both of these cases that you're pleading guilty to, whether in this court, any other court or administrative agency, correct?
Yes.
And you understand what the 25.136 status is.
Yes.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Any immigration issues?
No.
Counsel, if you can please voir dire your client.
Were you operating a motor vehicle on June 4th, 2021 in the city of Wyandotte?
Yes.
Were you pulled over, and when you were pulled over, did you fail to provide that officer with a valid driver's license?
Yes.
On August 1st of 2025, were you in the city of Wyandotte?
Yes.
And on that date and time, were you in possession of a controlled substance?
Yes.
And what was that controlled substance?
Psilocybin.
And also known as mushrooms.
I didn't hear that, sir.
Mushrooms.
And you understand that in the city of Wyandotte, those are illegal?
Yes.
So that's why you're on.
All right. The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to both pleas. And counsel, as to bond, because the court's going to schedule sentencing on the 251136 matter, and then we can handle the sentencing on the driving or allowing a licensed person to drive, and the court will note that on 211485 will be dismissed by way of plea, but there is still a warrant fee that is owed on that case. And so counsel, as to sentencing on the 211099 matter,
As to sentencing?
on the allowing a licensed driver drive.
Oh, you're sentencing today, or
We can do that.
I would just ask for costs and fines on his behalf. He understands he cannot and will not be operating a motor vehicle till he does restore his drive privileges, which I think he might be eligible to do so now. So that's his next step.
All right. And so, sir, how'd you get here today?
I rode my bike.
From Trenton?
No, I live in Wyandotte.
And how long have you lived in Wyandotte?
About 3 months.
Did you notify us? Did you give us notice of your new address other than on your advice of rights?
No, just the day I was arrested.
Okay, well, they still had your
Yeah.
front address. If you were to test right now, sir, what's in your system?
No.
Where do you work?
Right now I'm unemployed.
How do you support yourself?
I've been doing jobs on the side. I have an interview at Parole today. I've been dealing with health issues, like chronic liver disease.
All right, what happened with your matter in Canton in March of 23? Shows dangerous drugs and a traffic offense.
Yeah, it's something I need to get straightened out. I went through a really bad marriage in 2019 through 2022. And a lot went on in those years that I'm still trying to.
All right, have you taken care of your traffic matter from May of 23 in Riverview?
I believe so.
Okay, Ally, does it show that he has any pending cases here?
Promise after this.
No, nothing's okay.
Okay.
Yeah, I haven't had a license in over 2 years, and yeah.
Well, is the warrant fee on the 211485A, is that $50? Okay, it's $100 warrant fee on that one. So, sir, do you recall why you were driving back in June of 21?
Yeah,
And why was that?
because I was arrested and
I know you were arrested, but why were you driving? You didn't have a valid license. Why were you driving that
to
day?
get to work, I believe.
Okay. So, sir, who are you residing with that helps support you right now since you're working just some part-time jobs?
Just me, myself.
Okay.
Mm.
All right. As the 211099, the court's going to order a $200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $525. Is there a warrant fee on that one, Amy?
Thank you.
All right, $50 warrant fee. And sir, just so you know, I don't know if you've already taken care of it, but on the matter that was dismissed, you did have a traffic citation that defaulted. Okay, so you need to make sure that you're setting something up. When you stop at the window, you can set up a payment plan or something with that. So the total on this one is $575. So I know that you had a bond that you posted. No, you did not have a bond. You have a bond you posted on the 25 case. So I'm going to have you, sir, how much can you commit to paying $25 a month on this case?
At the end of the month, yeah.
That's yes?
Yes.
All right, so end of the month being November 26th. Would that be sufficient, sir?
Yes.
All right, so on this matter, $25 per month beginning November 26th. Do you happen to have the warrant fee to pay on the 211485A matter today?
No.
Okay. So is that also $25 per month that you can begin to pay?
Yes. And
Also beginning November 26th?
yeah,
Yes? All right.
yes.
Okay, and I'm sorry, if you were to test right now, sir, what's in your system?
Um,
All right, the court's going to continue your cash bond. You're not to possess or consume any alcohol or drugs unless prescribed. And sir, contact the courts that you have warrants with to begin clearing up your warrants, okay?
yes.
At least get the information that you'll need for that purpose, okay? Is that yes?
Yes.
All right, stop over at probation. Somebody will be with you shortly. Thank you. Let's go on the record in the matter of the city of Wyandotte versus Kevin Conaway, 251185. Can we get Mr. DeBoy in here, please, so I can start?
Attorney Corey Westmoreland, Craig, on behalf of Mr. Conway. Mr. Conway, would you please state your full name for the record?
My name is Kevin Conway.
All right, and good morning. Today is the date scheduled for the arraignment pretrial in this matter. Counsel asks to the arraignment.
Yes, Your Honor, at this time we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and then as to the pretrial, counsel.
Yes, Your Honor, at this time the city attorney has offered to amend the original disorderly person to one count of breach of peace. My client would like to plea no contest to that charge.
What's the basis for the no contest plea, counsel?
Insufficient memory.
Sir, please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matter be the truth, the whole truth, and nothing but the truth?
Yes,
And you've heard the plea that your attorney has placed on the record, correct?
yes,
As to the amended charge of disturbing the peace, how do you plead?
no contest.
You understand. You've gone over the rights that you've gone over your advice of rights with your attorney, correct?
Yes,
And you understand all of those rights.
yes,
You also understand by entering into a plea that you'll be waiving some of those rights.
yes,
You understand how the court treats a no contest plea.
yes,
You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
yes,
Knowing all of that, do you want to continue with your plea?
yes,
You also understand, sir, that the recommendation is fines and costs only, but that this court, that's a recommendation only, and this court does not have to follow that recommendation. Do you understand that?
yes,
Knowing all of that, do you want the court to continue your plea?
If that's what you want. May you repeat the question, Your Honor?
Knowing all of that, do you want to continue with your plea?
yes,
Okay, and counsel, your client doesn't have a recollection as to what happened 3 months ago?
That's correct, Your Honor, but he is here to take responsibility for it today.
I was presuming I was going to read something regarding level of intoxication, but that doesn't seem to be the case.
Drug all involved, Your Honor.
Right, that's why I was confused as to why there's a lack of recollection, given the circumstances that it's alleging in here. But the court will review the report here for the factual basis. All right, the court will accept the plea as knowing, voluntary, and factually accurate. And counsel, do you want the court to proceed with sentencing right now?
Yes, Your Honor, I think that would be appropriate. Mr. Conaway, as known by our criminal history, this was a completely isolated situation. He plans on learning from this and moving forward. He is gainfully employed at a detail shop. With all that, Your Honor, I would just ask for costs and violence.
All right. It shows that do you have an operating while under the influence, sir, out of Iowa? Yes, no, this is not you. Sir, I'm not sure why you didn't use the bathroom that day. You were right next to the bathroom. Why didn't you go inside the bathroom?
Just thinking.
I can't hear you.
I was not thinking I was being, stupid. Not thinking at the moment.
Well, sir, well, hold on a moment. You were right next to the bathroom. Why didn't you enter the door and go into the bathroom?
I didn't think.
Your Honor, it was an isolated incident. It's never going to be replicated in the future.
Sir, there's a graduation party going on there. Don't go back to the parks.
No.
The court's going to order you not to return to any park. The court's going to find that there's reasonable grounds to depart on scale 769.5. I'm going to order 6 months non-reporting probation. That's strictly to make sure that you're not going to any parks. You're not violating this court's order. And the court's going to order, are you working, sir?
Yes.
And I'm sorry, where do you work again?
Detail shop.
Oh, that's right, detail shop.
Cars. Yes.
$200 fine, $200 cost, crime victim assessment fee of $75, justice system assessment fee of $50, $525. We're going to have you set up your payment plan through probation, okay?
Yes.
All right, so you're going to go over to probation, sir. They're going to give you, set up a payment plan, and then, make sure you're not going to any parks.
Okay.
Let's see, the city of Riverview or Wyandotte versus Candace Hardesty, 251509. And there's also 24239.
Your Honor, good morning. Richard T. Toronto, PC 3828. Your Honor, I appear on both matters for my client, presently housed in Wayne County Jail. And please state your name for the record.
Not to unmute.
Candace Hardesty.
Right. And so counsel, as to, there's two matters up today. There's a pretrial set because your client was in custody on October 27th for her arraignment, where she's charged with fraudulent scheme and possession of controlled of drug paraphernalia. And then the probation violation alleges, while she was on probation for possession of drug paraphernalia, that she failed to appear for drug testing May 16th of 24, May 18th of 24, May 21st, May 28th, and June 5th, all of 24, and failed to submit proof of her submitting 20 job applications per week. As to the probation violation, counsel, what's happening?
Your Honor, the probation violation is pleading guilty.
All right. Ma'am, please raise your right hand. Solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay, and you heard the allegations on the probation violation, correct?
Yes, ma'am.
As to those allegations, how do you plead?
I plead guilty.
On over your advice of rights for probation violation purposes with your attorney, correct?
Yes, ma'am.
And you understand all of those rights.
I do. Thank you.
You also understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am. I do.
You also understand the possible penalty as a result of your plea.
I do, ma'am. Yes.
That the recommendation is for probation to be revoked, the case closed without improvement, probation violation fee to be assessed, and the 90 days jail. You understand that's the recommendation.
Yes, ma'am.
You also understand that that would be technical violations 1 through 6 that would enter, correct?
Yes, ma'am.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
And you've also heard, or I'm sorry, as to the more recent case, the possession of drug paraphernalia, how do you plead?
I plead guilty on that.
You've also gone over your advice with your attorney on that matter as well, correct?
Yes, ma'am.
And you understand all of those rights.
I do, ma'am. Thank you.
So understand by entering into a plea that you'll be waiving some of those rights.
Yes, ma'am, I do.
And you also understand the possible penalty as a result of your plea in this matter, whether in this court, any other court, or administrative agency.
Yes, ma'am, I do.
Knowing all of that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, ma'am.
Any immigration issues?
No, ma'am.
Counsel, if you can please pardon your client.
Your Honor, just for clarity, I did not put on the terms of the plea bargain on that case.
Oh, I'm sorry.
She's going to plead guilty and correct to possession of narcotic paraphernalia. If that plea is in fact accepted, the other companion case of fraudulent schemes would be dismissed on the prosecutor's motion.
Okay, and let me clarify. I did indicate that you had heard the plea that was placed on the record, but you had gone over that plea with your attorney prior to it being placed on the record, correct?
Yes, ma'am.
All right, counsel,
What here is the probation, Your Honor? Probation violation?
whichever one you would like to do first.
Okay, let's talk about the probation violation, Ms. Hardesty. You've heard the allegations and you've been advised that you have a right to have a hearing. Is that correct?
Yes, sir.
But you're pleading guilty though, and waiving your right to have a hearing. So, you acknowledge the fact that you were on probation to the 27th District Court?
Yes, sir.
Okay, and you were supposed to appear for drug testing on certain random testing dates. Is that correct?
I was,
You-
yes, sir.
You heard the allegations. The judge said that you failed to appear on May 16th, 18th, 24th, and 25th, and maybe another date after as well.
Yes.
Is that correct?
That is correct.
Right. And also you were supposed to submit 20 job applications per week. Did you fail to complete that as ordered?
I did at that time, yes, sir.
All right. I'm satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. Court will enter probation violations, or technical violations 1 through 6 in that matter, and counsel asks for the pretrial.
Your Honor, could I have the date of the offense, please?
October 26th.
Ma'am, on October 26, 2025, were you in the city of Wyandotte?
I was, yes, sir.
Were you a passenger in a vehicle?
I was, yes, sir.
And upon, you had contact with the police, is that correct?
I did, yes, sir.
And upon a consensual search to search your property and or person, the police discovered some narcotic paraphernalia in your possession. Two
Yes.
needles, a pipe, spoon, glass tube. Is that correct?
Yes, sir.
Were those fashioned to use for narcotic consumption?
Yes, sir.
I'm satisfied. You.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. And the court will dismiss fraudulent schemes and accept the plea of possession of drug paraphernalia. And would you like to do immediate sentencing?
Yes, if the court pleases, Your Honor. My client tells me that she's posted bond, but she cannot post a bond on this matter, so she's been sitting in custody. She says approximately 2 weeks. And Your Honor, she understands the recommendations, like those little recommendations as to jail. But Your Honor, she told me she's not just sitting idly in jail. She is getting some type of counseling there. She goes to some narcotic counseling, she told me. She wants to continue treatment, whether it be through the jail program or some kind of tethered program that the court gives her. But Your Honor, the important thing is she acknowledges her problem with drugs. She wants to get treatment, Your Honor. She said she possibly can get out, have a job waiting. As to all the missed dates, she tells me it was a bad time for her and that she is the primary caregiver for her elderly grandmother, and her grandmother was in her care until she finally was hospitalized and then passed away. So those reasons are, although not defense, those are reasons that she failed to appear. And as the job application, you've heard her admit guilt. But Your Honor, she's not just saying, well, give me the jail and I'll just sit idly by. She indeed wants to seek treatment, leaving the court's discretion.
Okay. And so, ma'am, you, are you wanting inpatient treatment?
Yes.
And the court will note that, while Ms. Hardesty was on probation for possession of drug paraphernalia and failed to comply with, it seems as though the majority of the terms of her probation in that matter. Then while she was on probation, she was still on probation, even though a warrant had issued for failure to appear for probation violation back on June 20th of 2024. The court will note that Ms. Hardesty was brought to the court based upon her arrest on fraudulent schemes and possession of drug paraphernalia, one of which is the same matter she was on probation for. So therefore, the court's going to order on the probation violation. The court's going to order 90 days jail, revoke probation, close the case without improvement, $50 probation violation fee. On 251509, the court's going to also order 90 days jail. She has been in custody for, I don't believe it's been 14 days, but I will count that out. 11 days. 11 days credit.
Thank you.
All right. Defendant to be tethered to treatment through the Wayne County Jail. The court will indicate that the 90 days will be concurrent.
Here.
The court's not giving 14 days credit on the 24239 matter. But she was in custody on the new charges. Yeah, and you still have your fines and costs due on the new matter. The court's going to waive the fines and costs. I'm sorry. The court's going to note you have the fines and costs still due and owing on the prior matter, the one that you are on probation for. Just because this court revoked probation does not mean those fines and costs are revoked. The court will waive the fines and costs on the 251509.
Thank you. Your Honor, this is a matter of housekeeping. The court recalled the bench warrant.
Yeah, yes, that was recalled on October 27th when she was arraigned before the court.
Thank you.
Good luck to you, ma'am.
Thank you. So this means I don't have a bond anymore, right? I understand.
What's that?
So what does this mean exactly? I didn't need to spend another 90 days.
90 days, you can be tethered to treatment.
Okay.
Okay,
Thank you.
you're welcome. We are on the record in the matter of the state of Michigan versus Jacob Cutie, 251303.
Your Honor, good morning. Richard T. Serrano, P33828. Today, Your Honor, I appear on behalf and with my client, appears to my right, this being and set for his sentencing. Sir, please state the name of the record.
Jacob Keating.
All right, thank you. And thank you for adjusting appropriately for court. Counsel, the court will note that Mr. Cutie did submit a typed statement to the court that it received on November 3rd that I did review prior to sentencing or prior to reviewing the or as I was reviewing the report and recommendation. Did you receive a copy of that, counsel?
I didn't see the copy, but my client and I talked about the sum and substance of that letter, Your Honor. We hope the court will adopt it.
Well, I have a question because I'm not quite sure. In the letter, it says that I asked for leniency or reconsideration of the charges considering the progress I'm making to address the underlying issues that led to this situation. So I'm not sure what that reconsideration of the charges would be because the court doesn't have the authority to reconsider the charges. If you feel as though you need to file a motion to withdraw the plea and otherwise discuss something, I don't know, that's something your attorney would have to do. The court does not do that.
I've addressed that with him, Your Honor. He does not want to disturb the charges. He wants to be sentenced today. Is that correct, sir? Yes.
Okay, and so your client was screened because he was interested in sobriety court, but was deemed to be low risk and therefore not eligible.
Correct.
Okay, and so counsel, if you'd like to, this is for second sentencing on a plea of operating while intoxicated. The original charge of operating while intoxicated second offense was dismissed by way of resolution between counsel and did you have an opportunity to review the report and recommendation with your client, counsel?
Yes, Your Honor, we have reviewed it. It is factually accurate. Just to briefly allocate on his behalf, Your Honor, my client is still wearing the court order tether. He's had no violations, is that correct, sir?
That's correct.
And he's 27 years old, single, with no minor children. He appears today with family support. And, Your Honor, he is working full-time as a food server. He's not on any doctor's care, taking no prescribed medications. There will be no illicit drugs in his system. Your Honor, we hope the court would adopt the recommendations. There's plenty of programs there for him to assess his alcohol use and or future consumption of that. Your Honor, the only thing that I'm asking is that he be given time to pay any fines and costs, but also that there was a bond posted that could be applied. Also, as far as the 5-day jail time recommended, I would ask the court to, since it's had no bond violations with the tether, probably consider suspending those 5 days jail, putting it in the court's pocket, so to speak. And so let my client prove to this court that he can stay sober, that he can abide by the court's conditions and sentencing ramifications. And with that, Your Honor, leave it in the court's discretion.
Okay, so Mr. Cutie, what is your driving status? What's the status of your driving license?
I don't have a license until next October.
Okay, and so how'd you get here today? Where are your parents? Okay. And where do you work?
I work in anywhere in Detroit. I'm mainly the DIA in Detroit.
Okay, so is it more of a mobile catering? Is that, yes?
Yes.
It's for weddings, wherever.
Okay. And so how do you get back and forth to work?
I work the same shift as one of my friends that lives close by, so he takes me. As long as they match up.
And if they don't match up, how do you get to work?
Uber, and that's how I get to school as well. Sometimes I my girlfriend take to school.
And on September 5th, what was your driving status? Was it valid?
It was yes.
And so your prior conviction
When we go back.
in 2024, what was your sentence for that, sir?
I was on probation for 6 months. They let me off early. So and,
So it was 12 months and you were discharged early at 6 months?
yes.
So do you have programs that you had to complete for that probation?
I had to do a Zoom meetings. Just a few. I came up with whatever.
Well, perhaps there were a few too many. What other conditions did you have to complete, sir?
I just had to go get tested twice a week at the beginning, and then it's dropped down to once a week, and I had community service.
Just had to test. So it seems, sir, in your communication that it seems as though it was very minimal
Maybe
and that your thought process of the conditions were also minimal.
at the time, yes. But I'm trying not to now.
Well, sir, you weren't even off probation for a year and you already violated again. You know what you feel like when you're at the 0.08 level. What was your level at the 33rd District Court case?
It was a 0.01.
Nope, that's going to be right. Nope.
0.10? The matter that you had in the 33rd District Court, do you recall what your level was in that one?
Not accurately, no.
He did successfully complete that probation offer. Is that correct, sir?
Yes.
Yes, but clearly the conditions that he had didn't really stick.
Well, if he goes to the programs that he's recommended, I think he'll get the idea, Your Honor.
And then I know what I've done, what will occur if this were to happen again. So I will stick that way.
Sir, prior to this issue, right, how often did you drink?
Here and there, if most once a week, that'd be socially. But something not every week, but if I were to say once.
Did you have to participate in the Mad Victim Impact Panel for the 33rd District Court? And so clearly that didn't resonate with you either, sir. The consequences and the life-altering, permanent consequences that are a result of individuals that are driving while intoxicated clearly didn't resonate with you. What was your point going out on, well, I presume it would have been September 4th, because this was at 2:30 in the morning on September 5th.
It was stupid. My girlfriend and I had gotten into a fight and I just needed to get out. I should have just walked around my home. I should have stayed there.
What did you get in a fight about?
She did. She wanted to come over and I just asked for a little space and just gave a thing. But
So she wasn't even at your house?
no, I wish it was.
Well, hold on. So she wasn't even at your house and you still got in the car and drove after you drank
Yes.
whatever you drank.
It was really stupid. It was one decision.
Well, it's a poor decision, sir. Fortunately, your poor decision didn't result in the loss of anybody's life. And sir, I can, and I read your letter that you submitted to the court. I also can appreciate that you are sorry for your behavior, yet have you ever heard the phrase that actions speak louder than words?
And I will. I'm so.
Because in this case, sir, you weren't even off probation for a year. And your actions spoke very loudly that you really don't care about the consequences. Because those consequences were right in front of your face just a year ago. The court's going to find that there is reasonable grounds in Department MCL 769.5 based upon hearing from counsel, hearing from Mr. Cutie, reviewing the report, the recommendation, the police report, the communication Mr. Cutie submitted. The court's going to find that the following sentences in the best interest of justice is reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. Cutie and the legislative guidelines. The court's going to order 24 months probation. You're eligible for early discharge, and the court will go over that shortly, which you're already familiar with, sir, but let me assure you, do not rush through probation and these conditions, because clearly you need a refresher in the conditions that you did have, because it didn't stick. It didn't resonate with you. You hurried up just to check off a box to say that you were done with it. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. Continue your outpatient substance use counseling. How often do you go, sir?
I try to go every other week, but sometimes work interferes with it.
Okay, this needs to be a priority.
Okay.
So if your work interferes with the schedule for your therapy, then maybe move up your therapy to be a continuing or a recurring date and time every week. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so you can maintain sobriety and prevent relapse. Hopefully preventing this matter from happening again. Now, sir, you've been fortunate enough that both of these times that you've had this issue, you haven't killed anybody. May not be as fortunate. You are to participate in the Armed Weekend program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use and allow you to learn trust and coping skills. If you were to test right now, sir, what's in your system?
Nothing another.
You are to attend again the MAD Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the dangers of driving while under the influence and to educate you about the consequences of such behavior. You are to perform 15 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life skills and get back to the community. You don't have a valid license right now?
No, Your Honor.
Okay. The court's going to order 5 days jail. I'm not suspending that. Mr. Cutie, the court finds that Mr. Cutie would have significant benefit in having to serve 5 days so that he understands what is awaiting him if there's a violation of probation or if this occurs again. And sir, what is your work schedule this week?
I work Friday, Saturday, Sunday, and I have a test as well this weekend. I have a presentation as well. I have an essay to start as well this weekend.
Can you report Monday if the court lets you? Report to go to jail? Can you report Monday? This coming Monday?
I have school, maybe sure.
Well, it's got to take priority over anything. Your Honor, with the
Sir, what is your class schedule, sir?
Monday, Tuesday, Wednesday.
And what is your work schedule next weekend?
I usually work every weekend. Every
Okay,
Friday.
you're going to have to request next weekend off, sir. I'm not going to have you, I won't have you do it this weekend because it probably won't be within the, that's short notice. So you are to report November 13th by 6 p.m. That won't interfere with your class, will it?
Your Honor, is the court going to assess a 1 day credit? For the arrest date?
Well, then the court's going to order 7 days jail and I'll give your client credit for 2 days,
Okay.
but your client's going to serve the 5 days. The alcohol tether will remain on until you report to jail. As to do you have any questions regarding those conditions?
No.
The court's going to order a $500 fine, $100 screening assessment fee, $1,200 supervision oversight fee. That's $50 a month at 24 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce $600. That's 15 days at $40 a day. And so that total is $2,825. You did post the bond. You can apply the bond. You can set up your payment plan through probation.
Is it correct, Your Honor, that some of those costs will not be necessarily needed to be paid immediately due to the possibility of him being eligible for early release?
Up to $600 would not have to be paid pending the early release or early discharge. Other than that, the balance would have to be paid. Sir, as I indicated, you're eligible for early discharge as long as all of the following have occurred. You complete at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and you've either paid your fines and costs in full, or you've made a diligent effort in paying those fines and costs. You seem upset.
Myself.
What's that?
Myself.
Well, sir, you should be. You quite should be. You should also be thankful that this is the extent and that you didn't kill or seriously injure somebody or yourself.
So I've told him, Your Honor, that it's a possibility if he gets another one of these, it could be charged with a felony.
100%. Stop over at probation, sir. All right. Good luck to you.
Thank you.
You're welcome. Okay. All right. Let's go on the record in the matter of the State of Michigan versus Anthony Kesselute, 251326.
Right here. Good morning, I'm here on behalf of Anthony Kesselute. Mr. Kesselute, please state your name.
Anthony Dominic Kesselute.
Thank you.
All right, thank you. And today is the date scheduled for the sentencing in this matter on your client's plea to an amended charge of operating while intoxicated first offense. The second offense notice, the second offense was dismissed by way of resolution between counsel at the pretrial and counsel as to the report. Is it accurate?
Yes, Your Honor, we've reviewed the report. He wants to give a bit of an update. I'm not sure if actually it's stated here. He is currently employed as a letter from his employer attesting to his work ethic.
I'll take a look at that. Thank you. Okay, what is bagging? What is this? What type of work do you do?
It's production. We do salt, sand, gravel, dirt.
Okay. And I ask because it's it referenced the arduous nature of your company, of the
Yeah,
company.
It's a lot of physical labor there.
Okay,
It's very physically laborious.
okay. All right. And counsel, what else would you like to, is this for the court to keep?
Yes.
Okay, thank you.
Well, in addition to that, the client has been attending a program called Men's Life, which is a support group to help him get a hold of his addiction issue. This is through his church. That's the Metro City Church. The pastor there is acting sort of in a sponsor role for him. And he explains to me that he's getting quite a bit out of that and intends to continue doing that. And so weekly.
Yeah, it's every Saturday, and then I talk with the pastor on Sundays. So there's Men's Life is on Saturday. I talk with Pastor Jonathan on Sundays.
In addition to that, he has written a letter to your honor. He'd like you to read it, express his thoughts and his apology to the court, etc. If the court would be so inclined.
I can do so unless you would like to read it.
If I could read it.
That's fine.
Okay. Your Honor, I want to start by taking full responsibility for my actions. I understand how serious this offense is, and I'm truly sorry for the decision that led me here. I know that driving under the influence could have hurt someone, and I'm thankful it didn't. I take that very seriously, and I've been doing everything I can to show that I've learned from it. Since my arrest, I've stayed completely sober and been fully compliant with my SRAM tether for over 20 days now. I understand that my BAC was very high, and that's something I'm not proud of. I've taken steps to address that by attending a men's group through my church every week, where I also have a pastor who mentors me. These meetings and that support have made a real difference in how I handle stress and decision making. I understand from my assessment that there are recommendations that the court allows. I'm willing to follow any conditions for counseling, outpatient classes, and more continued monitoring. I believe I can get more long-term benefit from my ongoing treatment and accountability through probation than from being incarcerated. I've already served 42 days in custody between my full violation and county time, and I've learned from that experience. I've used this time to reflect on how I want to move forward. I know this is my second offense, but I'm committed to making sure it's my last. I'm currently working full-time production line, and I take pride in being a reliable employee. My employer knows about my situation and has supported me through it. I also take care of my elderly grandfather. Being there for him has helped me stay focused and grounded. I'm asking the court for the opportunity to continue working, caring for my family, and staying active in church and recovery support system while completing any treatment the court requires. I want to keep proving that I can do the right thing every day. Thank you, Your Honor, for taking the time to listen and for considering my situation fairly.
Okay. And so, did you write that prior to coming into court today?
I
Did you write it while you were waiting?
I've been thinking about it, so I've just been trying to figure out how to word it all properly.
So then you heard me speaking to other people today and thought you should probably make sure you put your thoughts in a concise.
I want to be able to put them in something instead of just coming in here and just,
Okay. So here's here's where there's a bit of a conundrum, because the purpose of probation is to give individuals the tools to rehabilitate and not reoffend. And you have a prior alcohol-related driving offense in June of 19, which shows operating while intoxicated, which Perhaps there was another one somewhere along the lines that you were not given the opportunity to have that amended to an impaired. I don't know. Because typically a first offense is reduced to an impaired. So with that not being reduced, that tells me that there was likely something else that was occurring simultaneously or prior to. So possibly this could have been your third offense. I don't know, because I don't have that information somehow. Not only that, sir, you've been in state prison. You realize that you're not allowed to even use alcohol while you're on parole. It's a condition of your parole, sir. So that tells me either you didn't mind your time in custody, or you have a complete disregard for the law. Because you know, sir, that if you're drinking alcohol, that's a violation of your parole. So not only did you drink alcohol, then you got in the car and drove. In a residential area where you were doing 53 and a 35. Right? Because right where you were at, that's where there's the townhomes. Right? Well, yes, at 1:30 in the morning, you would hope that there wouldn't be kids or people running across the street, but you don't know that. And with the level of intoxication that you had at a 0.197, your reaction time, sir, is significantly impacted. And so I can appreciate, sir, that you have taken the steps and you're doing some recovery services for yourself. But I have to be able to find rehabilitative conditions to place you on probation. And I'm not sure if I can find any.
I could add anything, Your Honor. I mean, it's nothing, but I do have to meet my tether officer every other week for my scram tether. I have to see. I'm currently seeing my parole officer every other week again. She does do drug testing for me. She does do alcohol swabs for me. I know what I did. I should have done it. There's no excuse for it. I had an emotional lapse at the time. It's no excuse, and I understand that. But I just, from the time that I was on parole, I had a year of parole where I didn't have any skills. It did take me a long time to find a job. I got out of prison in August of 24, and it took me almost 9 months to find a job. And my employer, once I did get the job with him, even after the arrest, he did tell me, you do have a job, you've been a hard worker. So that's why he rehired me as soon as I got out for the full, and they rehired me back into work. And I do take this seriously, and I do know that I need the help, and I just feel like more incarceration won't help me. I feel like this stuff that I'm doing right now, the church, the group, outpatient care, any classes, continued work, helping my grandfather out, I feel like that will help me stay grounded and accountable for these actions. I am on the scram tether, obviously, even after this one comes off. If it did come off or whatever, my parole officer is putting one on me too.
Okay, so let me ask a couple questions based upon what you've stated, sir. How often were you meeting with your parole officer prior to this offense date on September 6th?
It was every 2 weeks when I first got out of prison, and then after that, because I had been doing well, it was only a monthly check-in.
Okay. And so, knowing, sir, that it took you 9 months to obtain employment and that you're on parole, why in the world would you want to jeopardize all of that and consume alcohol?
Yes.
Okay, let's just start with that. Consume alcohol. Why would you want to jeopardize all of that, sir?
It was a mistake on my part.
Well, obviously, because you're here.
I had a girlfriend at the time. Everything was going good with her. I hadn't quite figured out how to broach the I've been to prison topic with her. And one of her friends had invited me and her to her wedding and said, "Can I get your boyfriend's information?" She gave her my information. She had looked me up, found that out, sent it to my ex, and that was the conversation we had. She broke up with me. I'm not saying it's any excuse to go drinking, but it was hard to find somebody who was, as active in my life as she was. And I mean, she was a great person, and it was just hard to lose that. I know drinking isn't the answer to that, and that was my mistake.
Well, I'm sure I can understand that because given what your charge was that you were in prison for, I can completely understand, right? This is the second person now today that decided they were going to drink and then go get in a car after they had a problem with their girl. Why were you at home when you were drinking, sir?
I was at the bar.
So after the fight, you went out when you went to the bar.
Well, it was about a week after she had broke up with me, and we'd been texting back and forth, and I was, like I said, it was a bad emotional lapse in judgment there. Went to the bar. She had texted me and said, we never had our last night together, and me just thinking to myself of just seeing her one more time, I shouldn't have done it, and there's no excuse for it, but that's why I got in the car. I was so excited to see her. She's like, come over. And
Then take an Uber.
yes, Your Honor, that's what I've been doing for work. I've been taking an Uber every day to and from work if I can't get a ride from one of my coworkers.
Do you have a valid license right now?
No, Your Honor, they suspended my license. So anytime I can get to my men's life, it's either my uncle driving me there, or if I can get take an Uber there.
And so I heard your statement that, incarceration won't help you, right? Well, sometimes incarceration, sir, isn't meant to help somebody. It's meant to put it into perspective the consequences of your actions, right? And I'm not sure how many chances one person believes they need to have. All right, I'm going to take a brief recess and then I'll recall this matter. Just a couple moments. All right, let's go off the mic.
Everyone, please rise.
All right, and we are recalling the matter of Anthony Kesseloop, 251326.
Dan O'Neill, the boy, I have manager facility station name.
Anthony Kessler.
Okay. All right. And so the court did take a recess because the court wanted to look into a couple more things prior to proceeding with sentencing after hearing Mr. Kesseloop's comments as well as counsel's advocacy and whatnot. This is a difficult case because Mr. Kesseloop is before this court for an operating while intoxicated, which was reduced from a second offense. Mr. Kesseloop also is on parole for his conviction in March. That conviction being manslaughter, which would then preclude part of some of the conditions that the court could potentially put forth for an individual for an operating while intoxicated second offense matter. And the court has to take into account the safety of the staff as well. And that it has to be a consideration this court takes into account. Further, the fact that Mr. Kesseloop is on parole and is still violating parole conditions and consuming alcohol has to be a factor this court takes into consideration. So based upon all that, based upon the level of 0.197, the court does not find that there's reasonable grounds to depart from MCL 769.5. The court's going to order 60 days jail. How long did it take for you to get your tether, sir?
It took, I did the 35 days in Eaton County when they brought me back to Wayne County. It took about a day to get the tether on.
Okay, so I'll give you a day credit for that, and then I'll give you 3 days credit for the time that you're in custody awaiting arraignment in this matter. And so that will be 4 days credit. The court's going to also order a $500 fine, $100 screening assessment fee, $300 supervision oversight fee, $75 crime victim assessment fee, justice system assessment fee of $50 for a total of $1,025. You did post a bond of $1,500. So I don't know if Bethany wants to, it was a third party bond. So I don't know if Bethany wants to apply that bond or not. But if she does not want to apply the bond, then I will indicate that you are to contact the court by end of January to set up a payment plan. All right. You're gonna be going out this door today, sir. Good luck to you.
Thank you.
All right, let's go on the record in the matter of the state of Michigan versus Marlene Myers, 251543. And detective, if you can please state your name for the record.
Detective Chelsea Haskin.
All right, please raise your right hand. You solemnly swear from testimony about to give in the matter be the truth, the whole truth, and nothing but the truth.
I do.
Okay, and you may proceed on the warrant.
November 4th, 2025 at 3:18 hours, Wyandotte Officer Kate Cox was patrolling the area of Fort Street and Oak Street when he observed a Jeep Compass with tinted windows and numerous items hanging from the rearview mirror. A lien check indicated the vehicle was not insured. Officer Cox initiated a traffic stop. Officer Cox made contact with the driver, identified as Marlene Myers. Myers stated she did not have a driver's license on her. When asked if she had a driver's license, she stated yes. Myers appeared nervous while speaking with officers. Because she had no identification on her, she was asked to step out of the vehicle. Myers immediately stated that she did have her license and opened a black pouch, fumbling through it with her identification in view. Myers gave her Michigan identification card to Officer Cox and affirmed her license was suspended. Myers was asked to step out of the vehicle. She consented to a search of her person. When asked for consent to search the vehicle, Myers made several incriminating statements. Myers admitted to having drugs in the vehicle in the red bag on the passenger seat. Officers retrieved the red bag, locating 3 Ziploc bags containing a crystal substance, which later field tested positive as methamphetamine. The combined weight was approximately 19.21 grams. Further, officers located a scale and 2 meth pipes. A lien check confirmed Myers' license was suspended.
All right, upon examination of complaining witness, I find that the offenses charged were committed. There's probable cause to believe defendant committed those offenses. And counsel, your appearance, please.
Your Honor, good morning, Richard T. Serrano, P. Today, Your Honor, counsel, for arraignment purposes only on behalf of the defendant Myers. Please state your name, ma'am.
Marlene Myers.
All right, thank you. And counsel, as to the arraignment.
Your Honor, I've had an opportunity to sit and interview my client. I've also advised her of the nature of the charges against her, all maximum penalties involved, and possible consequences, be it from this court or any administrative agency. She understands everything, Your Honor. She's been advised of her rights of rights. She understands those. And we enter a plea of not guilty, where we stand mute, enter a plea of not guilty for arraignment purposes only.
All right. And ma'am, you have gone over your advice of rights with your attorney, correct?
Yes.
All right. The court will waive the formal reading. And you do understand that you do have the right to have an attorney to represent you. And if you're unable to afford an attorney, you may have one to represent you. Do you understand that?
Yes, Your Honor.
And in fact, you've had an opportunity to speak to an attorney today, correct?
Briefly, yes.
Sorry?
Yes.
All right. You also have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a trial by a judge or by a jury, and you also have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
The court's also signed the petition order for appointed attorney for felony matters. The court's going to enter a plea of not guilty on your behalf. Schedule this matter for a probable cause conference on November 13th.
9:15.
At 9:15 a.m. in council as to bond.
Your Honor, my client is divorced. Her 20-year-old son lives with her. And, Your Honor, she works full-time as a bartender at Main Event, it's called. And she tells me she has one matter, not on probation or parole, but she does have one matter pending in Southgate for misdemeanor, which she has a court date on November 18th. Your Honor, she had never failed to appear in court, she's told me. We would ask for a reasonable bond to be set. Understand the charges are quite serious. She understands that. But she's not going to be able to post a large bond, but we hope the court will consider, if not a personal bond she can reasonably expect to post. Thank you.
All right. And ma'am, what is your charge in Southgate?
It was a paraphernalia charge a week ago.
Okay. And have you ever failed to appear in court for any reason?
No, I always show up.
And I'm sorry, you said it's a misdemeanor?
Yes, ma'am. Yeah.
Well, I'm showing felony and misdemeanor. Felony dangerous drugs, misdemeanor dangerous drugs.
I'm really not sure, ma'am. It's so fresh. I'm not sure.
Well, ma'am, that would mean, if it's so fresh, that would mean that you would recall what that is, ma'am, if you were paying attention.
Well, I was paying attention. I thought it was a paraphernalia charge. That's what, I don't know. I work so much. I was just gonna show up at the court date. I don't know, Your Honor. I'm sorry.
You told me only a misdemeanor, Your Honor.
No, I understand that, counsel. And if you were to test right now, what's in your system?
My prescription medications.
Anything that's not prescribed?
Well, I just got off the methamphetamine and probably just a little bit of that. If it's still in my system, I don't know.
Okay, well, I'm asking so that if I'm ordering testing and there's something that's showing up, we have a baseline.
Okay, well, the baseline would be I get prescribed Xanax and that's it. And then I had stopped doing methamphetamine when I got that charge last week.
Are you, other than Southgate, are you out on bond in any other jurisdiction?
No.
Are you on probation or parole anywhere?
Yeah, I haven't been in trouble in 10 years, at least.
What do you do at the main event?
I bartend.
All right, detective, as to bond.
Your Honor, due to the seriousness of the charges, it is delivering, manufacturing methamphetamine, which is a 20-year felony, as well as the fact that she was just previously arrested on similar charges a couple weeks before in Southgate. I'm going to request a $20,000, 10% bond with a GPS tether.
The court would agree with that. The court does have to take into account Miss Meyer's criminal history, and specifically the fact that she is on bond for a matter for a felony possession charge out of the 28th District Court just about 12 days ago. Given the nature of these charges and the maximum penalty upon conviction in this matter being 20 years and or $25,000, given that Miss Myers doesn't have a valid license and she's charged with driving a license suspended or revoked or denied, the court does have some serious concerns for the safety of the public and the community at large. And therefore, the court's going to order a $20,000, 10% bond with the following bond conditions. You're not to possess or consume any alcohol or drugs unless prescribed. In the event you post bond, ma'am, you are to participate in random testing. You're not to operate a motor vehicle without a valid license. And you are not to be released without a GPS tether through the Wayne County Jail. No house arrest. In the event you post bond, you are to report to 27th District Court probation to set up testing. Bond. Posting bond. And receiving tether. All right, thank you. We'll see you back next week. Have a good day.
Your Honor.
All right, and is Detective Sabo there?
Yeah.
I'm sorry?
Not yet.
Oh, not yet. Okay.
Yeah.
I thought I saw Detective Sable in the audit, in the foyer here on a short time ago.
Well, maybe he is walking back now that Detective Haskins is done. Okay, let's go on the record in the matter of the city of Wyandotte versus Philip Labacani, 251545, 251518.
Attorney Corey Westmoreland appearing on behalf of Mr. Labacani. Mr. Labacani, would you please state your full name for the record?
First name is Philip, last name is Labcani. Thank you.
You're welcome. And all right, counsel, as your client is in custody, we are proceeding on the arraignment on the new matter that's alleged. The alleged offense date is November 4th. The offense date from October 24th there was notice that was not able to be notified to your client because he's homeless. And so we didn't have anywhere to send it. So it's arraignment on both matters. And so counsel, as to the arraignment.
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and schedule these matters for pretrial on November 19th at 10:15 a.m. Counsel, as to bond.
Yes, Your Honor. Mr. Labacani is currently looking to be staying at a shelter. He's not currently on probation or parole. He has no other pending matters other than these two. And after speaking with my client at length this morning, he did assure me he would be appearing at all future court dates and understands the importance of clearing these matters up. I would just ask that all that be taken into account when assessing a bond.
Okay, so sir,
Yes,
do you
ma'am.
reside anywhere?
What do you mean by resigning the work?
Where do you live?
I'm currently homeless right now. I would love and appreciate if I could get some help by taking care of this the right way and I get sent to jail. And hopefully I can get my responsibilities taken care of at the same time too, please. Like I'm really
Okay.
trying to get the help out here that I really need out here so I can stop going in circles out here because there's been a lot of times out here that I've been blessed and a lot of people out here and I haven't got anything back, but that's not
Sir, time out. Sir, time out. Time out for a moment. Are
Yep.
you under the care of a doctor, sir?
I was before when I was going through my medications and so forth. Back in the
And
day.
what medications were you on, sir?
I was on Depco and Lysantine or something like that. It was like a long
When's-
word.
Okay. Sir, when's the last time you took your medications?
About like maybe a year ago, maybe.
Okay. And so, how long have you been in this area, sir?
For this like a year or two, you know, I've been around here with
Because I saw that you were up at Central Michigan, just a few months ago.
I was up there and so forth. It's just gone through a lot right now.
Were you a student up there, sir?
No, I never went to school up here. I just came out here from Cali.
From where?
I came out here from Cali with my family and so forth, and I had family, and I got family not problems or issues, but I'm trying to deal with it, you know, and yeah.
When you say Cali, you mean California?
California, yes.
Okay.
I got moved out here with my family and so forth, you know.
All right. So where is your family?
One of them is in Westland and one is in Lake Grande.
All right. Counsel, given that your client doesn't have any residence to live at. And given that he has a pending matter in this court and he has a warrant out of Westland, and given what clearly seems to be some mental health issues that he needs to see have some treatment on and potentially have some medications re-prescribed to him, the court's going to order a $4,500 10% bond on each case. And you're not to possess or consume any alcohol or drugs unless prescribed. And the court's going to make sure the file is marked medical, sir, so you can receive your medical treatment.
How would that be possible when I get out today? Or
No,
when
you're not
I-
getting, well, unless you have, sir, unless you have $900, you're not getting out today. And if you're at the Wayne County Jail, then they are going to give you a medical evaluation and have you treated with the medical professional. Thank you.
So what's the deal here? Am I going to get released and get the help that I really need out here, or am I just going to be stuck in jail?
Well, sir, I would like to,
'Cause I'm on the bottom
sir?
where my brother took all my money.
sir,
And
Sir.
if I could get that back, I could pay that $900 right now.
sir, what I was going to say is that I would like to have you tethered to a treatment facility, a mental health treatment facility, but they don't have any that I can tether you to the Wayne County Jail. Are you asking for inpatient drug treatment? Is that what you're asking for, sir?
I'm asking for me to get released so I could start moving on with my life and so forth.
Okay, well, getting released without having to post a bond and a tether. Sir,
Like maybe
getting
next week or
released without
something.
having to post a bond is not going to happen. So we'll see you back on the 19th. Thank you.
So am I going to get released here soon? Let's go.
Not today.
So I'm going to get released now. If she's saying not today, why would I be released the next one day? Why would it?
Customer?
Right up to the podium.
Okay, well, hello, Mr. Stone. We're on the record in the matter of the city of Wyandotte versus John Stone, 251546. Counsel, your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Stone.
Mr. Stone, your name for the record, please.
John Stone.
Okay, and counsel, as to the arraignment.
Yes, Your Honor, at this time we are prepared to waive a formal reading. My client stands mute.
The court will waive the formal reading. Enter plea of not guilty for purposes of the arraignment and then schedule this matter for pretrial November 19th, 10:15 a.m. Okay, and counsel, as to bond.
Yes, Your Honor. As you're aware, Mr. Stone is on probation out of this district court. He is residing currently in Wyandotte. He has no other pending matters at this time and assured me that he will appear. As you're aware, he appears every time. He's not going to abscond from this honorable court. I would just ask that all that be taken into account when assessing a bond.
Well, although your client still is not taking care of his matter out of Battle Creek. Okay, Mr. Stone.
Yes, ma'am. I almost had 2 years sober and I roamed it all I almost had 2 years and I just roamed it all. And I'm sorry because I know you gave me the opportunity to do that.
I sure did.
I apologize, and I'm not working. We have no money. I can't make a bond.
Why aren't you working?
I can't find a job.
You haven't worked at all during probation?
I worked a little bit for a roofing company.
Okay, so what happened with that job?
It's out of town. At the moment, I was able to commute back and forth with a friend.
Okay. Well, sir. How are things going with your son?
Things are going really, really good. Being sober, definitely helped our relationship. He just finished his senior year of varsity football at Roseville. He's about to start wrestling again soon. So things are going really, really well. He went out of town, so I don't know why I did this after all that sober time, but
Sir,
he went out of town.
Sir, hold on.
Yeah.
I can't have you speak about the facts of the case right now. Okay.
Okay.
So, well, here's the issue. Okay. What I'm going to do, sir, is I'm going to order a $7,500 personal bond. You're not to possess or consume any alcohol or drugs unless prescribed, and you're not to be released without alcohol tethered through the Wayne County Jail. So
Did you say
we're going to
75?
help. Hold on, I can't hear you. We're going to help
Okay.
you get back on your sobriety path. What was that, sir?
Was that a personal bond you said?
It's a personal bond, but you're not getting released until you have an alcohol tether on you from the Wayne County Jail.
Okay.
Thank you, Judge.
We'll see you back on the 19th at 10:15 a.m.
Okay. Do I go down there to get it or?
They're going to drive you down there. You're going to take the ride in the van, I presume, with
okay.
some of the
All
other individuals that I've just seen. And then once you have the alcohol tether, then you can be released.
Okay.
Thank you, Judge.
Thank you, Your Honor.
I feel like even ready. Let's go on record in the matter of the State of Michigan versus James King, 251179.
Right here. No, Your Honor, Neil Blair here on behalf of James King. Please state your name, sir.
James King.
All right, good morning. Thank you very much for being very loud. And the court, sir, as to counsel, as to the arraignment in this matter.
Sorry.
I'm sorry.
This is a sentencing hearing.
No, I'm sorry, sentencing. I'm so very sorry. Change the date time scheduled for sentencing on your client's plea to an amended charge of operating while intoxicated. First offense, driving while license suspended and open intoxicants. And the operating while intoxicated second offense was dismissed by way of resolution between counsel. Counsel, do you have an opportunity to review the report and recommendation with your client?
I've gone over it. King indicates that there is an update, a negative update. His full-time employment at Quanta was recently terminated. Is that correct?
It wasn't terminated at Quanta. I had gotten a new job that I was waiting for at Steel Tool Engineering. And when they found out I had a tether, they fired me. And Quanta won't take me back. And I'm having a hard time finding a job. I've applied at multiple places. I'm waiting for Roush and the Oakwood Group to call me back, but no one's calling me back.
Okay.
And a roofing company I also applied for, but that they go out of state, so I don't know how that would work with everything I'm going through right now.
Okay.
So although currently unemployed, it's clear that he's attempting to remedy that as soon as possible. However, I think everything else in the report is accurate, sir.
Yes, sir.
Yes. So we get the conditions do seem in line with circumstances here. He would confer Obviously, the court to consider not assessing the jail at this time. Let him complete his job search, get his feet back under him, and he's committed to sobriety going forward. Anything else you want to add?
My tether officer told me I might be able to get this off at my sentencing. Is that gonna happen or no?
Sir, are you for real?
That's fine.
No, just one moment. You're here for sentencing on a second offense OWI, right? Well, actually, it's a first, but it's technically your second. And so instead of utilizing your opportunity to express any remorse or anything like that, you just want to know if you're getting your tether off. That's what I just heard.
That's what my tether officer told me.
You're missing my entire point, sir. You're missing my entire point. It was your opportunity to express your remorse to the court. If you have any. And instead of doing that and acknowledging the poor choice you made on August 8th, your first concern was whether or not you were getting your tether off. That's your concern. Not the amount of risk that you put forth to the community or yourself or otherwise. Tell me what's going on with your 3 warrants.
I was working on paying them off and I got fired from my job because of the tether. I was trying to save up money and I got fired, and I had the money I had to spend for sales.
So that's a, let's see, you failed to appear for a review hearing in the 23rd District Court, October 28th of 24. You've had a year to take care of that and you have not. You also have a warrant out of the 23rd for double parking that you didn't pay, which is $400. And then also from the same date, a warrant was issued for, because you didn't show up for paying your stop sign ticket, which occurred in 21, by the way. Let's be very clear on that. That occurred in 21. So you have those matters. And sir, let's just also be very clear that you just had the tether affixed when you were here for arraignment September 18th. So you had a lot of time that you could have taken care of your warrants and you have chosen not to do so. You also have a prior operating while impaired out of Van Buren in April of 22. And then you also have a fail to report from February of 25 in this court. And sir, how did you get here today?
I got dropped off.
Who dropped you off? How were you getting back and forth to work?
Co-worker who was vanished.
And do you have any keys in your pocket right now?
House keys.
No, there's, what else? What is that?
It's a bunch of random keys. There's no car keys though.
Oh, okay. If you're to test right now, sir, what's in your system?
Nothing.
So, sir, not only do you already know what your level is when you're over a 0.08 and you're not legally able to drive, right? You are more than twice that limit. You're more than twice that limit. And not only that, you're not even legally allowed to drive. And yet you were driving that day. Yet again.
My license had just got suspended at midnight. That wasn't.
But you had noticed it was going to be suspended.
I didn't notice it was the 8th. I think that was the date.
You received notice that your license was going to be suspended, correct?
Yes.
Right. So that's on you, sir, to know what date of the week it is. What date of the month, what day of the week. That's your responsibility.
Yes.
After hearing from counsel, hearing from Mr. King, reviewing the report, the recommendation, the court will find that there is reasonable grounds to depart from MCL 769.5. The court's also going to find the following sentence being the best interest of justice to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Mr. King and the legislative guidelines. The court's going to order 18 months probation. You're eligible for early discharge. I'll go over that in just a few moments. You are not to violate any criminal law of any unit of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, in writing, or virtually. You're to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms to maintain sobriety and hopefully prevent this matter from happening again. You are to participate in the Armed Weekend Program. The rehabilitative goal for that condition, sir, is so that you can further educate yourself regarding drug and alcohol use and learn trust and coping skills so that hopefully this will assist you in preventing this matter from happening again. As to, then you also have the MAD Victim Impact Panel that you have to attend. The rehabilitative goal for that condition is to help you further educate yourself regarding the dangers of driving while under the influence and the circumstances, the consequences of such behavior. The court's going to also have you participate in fan meetings once per month. The rehabilitative goal for that condition, sir, is to help you in maintaining your sobriety as well as receive some recovery resources. You're not to operate a motor vehicle. The court's going to order 10 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life and work skills and give back to the community. The court's going to order mandatory jail for any probation violation. And the court's also going to order 10 days jail. All that is to count 1 only. Counts 3 and 4 will be fines and costs only. As to, you have any questions regarding those conditions?
I'm going to jail.
Yes, please keep your hands out of your pockets. For 10 days, you're going to jail, sir.
Please. And I've done no alcohol, no drugs. Please, I'm trying to get a job.
So I understand that.
Please.
But my responsibility is not whether or not you get employment. My responsibility is to make sure the community is safe.
Please.
This is your second offense. And not only is it your second offense, you weren't even legally able to drive that day. And you were at a .178. You have a prior just a few years ago, sir.
Please, don't, please. I will do anything and anything.
Sir, that is the order of this court. After your 10 days, you certainly have lots of time that you can obtain employment. Because at that point, your tether will be removed. And you won't have to worry about having a tether be a reason why you don't have employment. As to your fines and costs, the court's going to order a $500 fine as to count 1, $100 screening assessment fee, $900 supervision oversight fee. That's $50 a month at 18 months. Since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. Workforce of $400. That's 10 days at $40 a day. So it's $2,325. As to count 3, the court's going to order a $300 fine. I'm not assessing a screening or oversight fee. $200 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $625. As to the open alcohol, count 4, $100 fine, $100 cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, for a total of $325. For a total between all 3 matters of $3,275. You did post a bond, so we will apply the bond, and then you'll have to set up your payment plan through probation upon employment. Sir, I can appreciate you haven't used any alcohol since you at least have been arraigned. Okay, so that's good. However, this court has a responsibility. You have prior charges. You have a first offense on the 22nd. You have 3 warrants, and now you have this matter. So that is the order of the court.
Well, I'd be able to call my mom so she can come grab some of my things. Only
You should be able to. I'm not sure they should. You should be able to make a phone call back there. All right, you're going to be going out this door today. Good luck to you, sir. Okay, City of Wyandotte versus Charles Burzloff, 251105.
Yeah, click right up. Good afternoon, Your Honor. Neil LeBlanc here on behalf of Charles Burzloff. Statement answer?
Yeah, Charles Burzloff.
All right, thank you.
Right.
And I do apologize for your delay today, sir. Somehow we missed your file on the table.
It's mostly my fault, man.
Your Honor, before we dive into that, I raise something with the court. I don't have an agreement with respect to Mr. Burzloff regarding any plea negotiation. I've been discussing this with city attorney and with Mr. Burzloff. I find myself unable to communicate with Mr. Burzloff. Laid out various options for him. He will not give me any direction. Other than set this for a trial, I'm at a loss here. But the plea offers, there were several back and forth. Not the court's, court doesn't even know that.
Right.
But at this point, I don't know what he wants to do in simple terms. I expressed to Mr. Burzloff that I can't make decisions for him. I've expressed that to him repeatedly, and he essentially does not answer my questions. This is a lack of communication, and I think ethically I'm bound to withdraw at this point. If he wants to pursue private counsel, if he wants to pursue the matter on his own, he's expressed an interest in speaking directly to the judge, speaking directly to the prosecutor. I said, I must step aside if you're going to do that. If you don't consent to allow me to step aside, then I must file a motion with the court. I'll make a motion now to do so. I don't know if he's changed his mind. He's had a considerable amount of time today to consider it, and I'm at a loss as to how to proceed.
All right. Well, first, you can't speak to me directly off the record for sure. And you can't speak to the prosecutor if you're represented by an attorney. Counsel, let me see you and Miss Kuzmiak. Which prosecutor was on this one? In Chambers. Okay. All right. So it'll be just a few moments. Okay, sir.
Okay.
What is that? Hand that to your attorney, please. Hand that to your attorney.
I have it, Your Honor.
You have it. Okay. So I'm sure that will be a topic of discussion in our chambers. Okay. So it'll be just a couple moments, sir. But Mr. I'm going to have you call this one.
Yeah, okay.
Yeah. So, sir, you can just have a seat. It'll be just a couple moments. Okay. And then we're on the record in the matter of the City of Wyandotte versus Andrew Chalk, 251181.
And step up.
All right, let's go back on the record in the matter of the City of Wyandotte versus Charles Burzloff, 251105.
Right, Your Honor, Neil LeBlanc here. We have Charles Burzloff.
Okay, and so Mr. Burzloff, your name for the record, please.
Charles Thomas Burzloff.
Okay, so counsel, so the court did have an in-chambers conference with the prosecutor present as well. Mr. Burzloff, your attorney made an oral motion to withdraw. The court is not going to grant that motion at this time. Mr. DuBois is still going to assist you in your defense. It's my understanding that there's some very critical medical information that you need to get to provide from that evening. Because it's my understanding that you went to the hospital after this incident, correct?
Yes.
That is the critical information that the attorneys need, sir. Only you can obtain that information. So do you have the app on your phone that you can access it?
I don't have a phone, man.
Okay. So then what I need you to do is as soon as you leave here, go right over to the hospital, directly to the hospital, and request the medical records.
You can't do that no more. You have to go downtown and get them.
Who told you that?
The hospital did. That's where I was downtown.
When did you go downtown? When did you go downtown?
the day I got the letter from, that I had to go to court.
Okay, so when you went downtown, did you get your medical records?
Yes, I got them, but my doctor, when I went and got this,
So you have your medical records.
my doctor has them.
Hold on, sir. What we need to make sure is that you have your medical records from July 27th or July 28th. You have those?
I got some medical record from this hospital, but they're all downtown now. They don't give them out at the hospital. You gotta go right down.
Okay, so I can understand that because they've gone to electronic medical records. So they probably only have one spot that they're housing the medical records. So you need to double check whether with your doctor or at your house as to the dates of those medical records, because you need medical records from your hospital stay in July that surrounds this incident. You have to have that. That's what Mr. DuBois needs.
Okay.
That's what the prosecutor needs.
This is no good then?
Well, it's not that it's no good, right? Because that confirms your condition. But it's my understanding that you were at the hospital as a result of your condition, is what you're stating, which could be a defense to the charge. So before anybody can proceed, you need the documentation from the night of the incident. Your medical documentation from the night of the incident.
Okay, but if it says that I've been drinking, I mean, I did.
Hold on. I don't want you to talk about the facts of the case. Okay.
Well, I was drinking, ma'am, but
Sir,
like I said,
hold on. Okay. Let me tell you something. It's possible that even if you were drinking, okay, you're still having a diabetic issue. Right? So
Yeah.
two things can be true. Quote to Kelsey Ballerini. Two things can be true. So the other thing that you need to be true is what you were treated for at the hospital. So that is what the documentation is that your attorney must have. So you must get that information and get that to your attorney before your next court date. Okay?
But I gave you that.
No, you didn't.
You did.
I'm not holding it, Mr. Again, Judge, I'm gonna renew my motion. He's accusing me of withholding his documents.
No. I'm saying I gave it to you and you read it.
From the hospital?
No, I had it here. I brung it here.
From the hospital.
Yes.
Then you have it at home.
No, my doctor has it. When I went and got this, he kept it.
Well, then you need a copy of it back. But Mr. DuBois doesn't have
I'm
it.
not saying you kept it.
I don't have your record, sir.
I didn't say you did. I said you read it. I brung it in here.
Me reading them does not resolve the judge's question.
It does not, because
Right.
Mr. DuBois has a lot of clients that he has to review documents on. Keep your hands out of your pockets, please.
Sorry.
And the prosecuting attorney needs to see those documents before they can put forth any resolution, if there's going to be one. I'm not saying there's going to be one. Mr. DuBois isn't saying there's going to be one. Mr. DuBois isn't saying that anything is going to be dismissed. But in order to proceed with trying to advocate in your best interest and hoping for a dismissal, right? He needs the medical records from the night in the hospital. Even if you think you showed them to him before, even if you did show them to him, showing him is not sufficient for the prosecuting attorney. They need to see them. So you have to get those from your doctor. Okay? All right. So we'll adjourn this to the 19th.
$9:45.
9:45 a.m. Sir, make sure you're getting those medical records.
9:45 and what day?
a.m. November 19th,
November 19th.
2 weeks from today.
$9:45. 9:45.
Yes. And hospital records are necessary. Bonding conditions are continued.
Thank you.
Thank you.
So I'm done.
Yes.
Thank you.
You're welcome.
Sure.
All right. Let's,
Hold on.
Oh, hold on, sir. Hold on. He wrote that down for you because that's going to be your only notice.